Good evening, everyone, and welcome to Sponsorship 101, What Migrants Need to Know About the Process, an event by Justicia for Migrant Workers. I'm Asaf, Rashid, immigration, refugee, and criminal defense lawyer based in Halifax, or Shabuktuk by its Mi'kmaq name, Nova Scotia. Because immigration is federal, the same rules apply in every province and territory to immigration through spousal sponsorship. So whether I'm in Halifax or anywhere, the same situation applies. I'd like to first give a land acknowledgement that Toronto is in the dish with one spoon territory. The dish with one spoon is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and protect the land. Subsequent Indigenous nations and peoples, Europeans, and all newcomers have been invited into this treaty in the spirit of peace, friendship, and respect. All right, so first off, I thank Justicia for putting together this event and to all those in attendance for making it. I'd also like to give a shout out to the poster designer. I just want to give a disclaimer that I am not a matchmaker. I'm going to be talking about spousal sponsorships, which is perhaps the most unromantic topic out there due to all the paperwork. We'll get to that. I'll suggest that questions happen anytime actually during the event, but they'll be answered at the end once I'm done my portion, just to make sure that I'm able to finish. I expect that my portion before questions should be approximately 15 to 20 minutes. So another disclaimer, I'm only giving legal information and not legal advice. I'm not telling anyone listening to do or not to do anything. I'm going to be giving a general overview to help you better understand the spousal sponsorship process and legal challenges to it. No one listening to this is my client just by participating in the event. If you have specific legal questions about your individual case, you will need actual legal advice and can contact a lawyer of your choice for this. Please do not give any specifics about your situation in the question and answer. I will assume all questions are hypothetical. So, first, a bit of an overview. To get married is actually the easy part in many ways. If you and your partner are both old enough and want to get married, you can get married. The official conducting your ceremony can't disagree with your relationship based on what they think about it. But to get married to Canada, which is basically what a spousal sponsorship is not so easy. To succeed in your sponsorship, you need to convince a doubtful immigration officer that you have a legitimate relationship, and unfortunately, they can say no. So I'll be presenting this as if I'm speaking to someone who came to my office who's interested in learning about spousal sponsorship. When I say you, I'm speaking to the imaginary person who's interested in sponsoring a spouse. So spousal sponsorship, first off, is a way to obtain permanent residence for the person who's applying. So the sponsor is the one sponsoring the applicant. Now, I'm not agreeing with how Canada treats spousal sponsorship today. I think it's actually quite discriminatory against people of other nationalities, the way the spousal sponsorship process works. My mother was sponsored many years ago by my father through a spousal sponsorship when it was less difficult. And it's too bad the Canadian government has made it harder in the last several years, but I don't decide the rules. It's important to understand and make sure you comply with the existing rules, even as unfair as they seem, and existing procedure in order to be in a position to succeed. So through the spousal sponsorship process, what happens is an immigration officer puts a microscope on your relationship to try and judge whether you are in what they call a marriage of convenience or a genuine relationship. So what does that even mean? Basically, if an immigration officer believes that the only reason for your relationship is for the applicant, that's the person being sponsored, to gain status in Canada, according to that officer, that's not a legitimate relationship, but is a marriage of convenience. If the officer accepts your application, it means they view your relationship as a genuine relationship. Now, it's all right if one of the reasons for sponsorship is status. That's basically part of the process. You gain status through the application. But the main reason for the application has to be the actual relationship and wanting to stay together basically forever. There are other requirements, but this is the biggest part of the application. Now, there is a lot to the process, and I'll only be able to go over the basics in this short amount of time. So for one, starting off with what does spousal sponsorship mean as far as what can you do through it? Well, there are two routes for a sponsorship if you're both in Canada. One is through a common law relationship and the other is through a married relationship. So for common law, the requirement is that you live together for at least a year, but ideally it's well beyond a year, much longer than that in the best of cases. To have convincing evidence, you need to prove a lot of dependency on each other. And I'll get into more evidence a little later. But we'll mention for now that it is harder to prove the validity of a common law relationship than a married relationship. I should add, if for some reason you can't be physically together because one has to leave the country due to the nature of their permit in Canada, then there's still a way to be successful by demonstrating that you still maintain a close, strong contact during that time. So if you're married, you have to be living together while you're both in Canada. That's a requirement. For a married sponsorship, you still need a lot of proof, but the proof of the marriage and the ceremony goes a long way, and I'll get to that. So who can be a sponsor? The basic eligibility requirements, and this is a summary, this doesn't cover all the details because there's actually quite a lot, but the key points are only a Canadian citizen or a permanent resident can be a sponsor. And if a permanent resident is on a removal order, then that disqualifies them. You have to be over 18. You can't be on social assistance, and I'll get to more on that later. That's a very important point. You cannot be the married or common law spouse of another person at the same time. If previously married, you must have a divorce certificate or at least a separation agreement if you are sponsoring through a common law sponsorship. You can't actually be in jail while you are making the application for sponsorship as a sponsor. You can't have a conviction for a sexual offense or of a family violence related offense in the last 5 years. And also, if you're charged with a very serious criminal offense, that can have a pretty strong impact on the success of your application. You can't be in default of child support inside or outside Canada. So if you owe child support payments, you're behind in them, you're in debt with child support payments, then that will be a barrier as well. You can't be in debt to the immigration department, basically. That means you have an immigration loan that is unpaid, and that's very specific. People can get an immigration loan, such as those who came to Canada as refugees and got a loan for their flight and haven't paid it back yet. You can't be in default of a previous sponsorship undertaking, and I'll get to that. There's an agreement that every sponsor has to make, and if you're in default of that from a previous sponsorship, then you're ineligible for a new one. You can't be someone who was sponsored within the last 5 years either. So if you were sponsored 3 years ago and your previous relationship ended, you can't then, even if you're a PR, you can't then sponsor someone else. So who can actually be sponsored through a sponsorship? So now we're talking to the applicant, the person that you're trying to sponsor. Well, your spouse, that's either married or common law spouse, and dependent children of that spouse. So the spouse and the dependent children would all be the non-Canadians and non-PR people that you're trying to sponsor. And dependent children have to be under 22 on the date that the immigration office receives the application. That's not the date you fill everything out. That's the date they actually acknowledge, we got your application, we looked through it, and we're going to process it. That doesn't mean you got accepted. That just means they have acknowledged that they've received it. So if there's dependent children who are older than 22, it's possible for them to also be included in this sponsorship, but only if there's a particular mental disability that makes them dependent on their parents on an ongoing basis. So basically, they're unable to take care of themselves. So the applicant also can't be inadmissible to Canada. There's so much to that, but basically the government has made a number of rules that say certain individuals are inadmissible for breaking certain rules in Canada, basically immigration rules or criminal code of Canada. So someone has convictions, and as a result of that, they have an order against them that they're to leave Canada, basically. But there are ways to make challenges to inadmissibility through making an application or including it in your spousal sponsorship application that there are humanitarian reasons that the officer should accept your application anyway. But that just makes it more complicated. So part of the process is, as I mentioned, there's this agreement that every sponsor has to make. It's so there's a number of forms. So maybe I should get to that first. The application process includes many forms that you have to fill out, including a lot of information about yourself, all jobs that you've had in the last 10 years, addresses you've had in the last 10 years, all kinds of information about your family, of course, all your personal details about your name, date of birth, et cetera, et cetera. Lots of information. No point in going through it all and boring everyone with it. Let's just say it's pretty thorough. And the other part of the application that's really important to mention is this agreement. So every sponsor makes an agreement with the applicant and with the Canadian government. The big part of this is the sponsor is responsible for making sure that the basic needs of the applicant are covered. It's really about avoiding the applicant's dependent on social assistance. And basically, I'll say this, the government basically really hates social assistance. And they have a very negative attitude towards people on social assistance. As soon as your application is received by the government, so the application is made with all the included documents, and I'll get to that soon. And at some point, there's a letter that you get back, or if you have a lawyer representing you, your lawyer will get, which is called the acknowledgement of receipt, which basically says your application has been received and we've looked at it and it looks like you have everything here, basically. So from that point forward, if your spouse is already in Canada as a temporary resident, right? So the applicant's already in Canada, then the sponsor, are responsible for making sure they don't go on social assistance from that point forward. If they do, you owe all that social assistance money back to the Canadian government. You're responsible for covering any debts due to social assistance for 3 more years after your spouse gets a permanent resident visa. So we're talking overall, this could be 4 to 5 years, possibly longer overall. And even if you break up, you still have this obligation. Now, the good news is that the applicant is eligible for an open work permit while waiting for a decision on the sponsorship. So you can actually work and keep working, but the applicant can't work until they get the permit. So it's not you apply for the permit and then you start working. You have to actually get that permission in the form of that open work permit before you begin working. So what is social assistance? This is such an important topic for this issue, unfortunately. Social assistance in Ontario, because I gather most people listening to this may be from Ontario. Social assistance in Ontario, we're basically talking about Ontario Works. It's assistance from the government to cover food, shelter, clothing, fuel, utilities, household supplies, healthcare not covered by public healthcare, extra benefits paid by the government to low-income people in need, but it doesn't include disability. So social assistance doesn't include disability assistance. So if you're getting assistance through the Ontario Disability Support Program in Ontario, then that doesn't disqualify you from being a sponsor. Employment insurance, and that includes the Canada Emergency Response Benefit or any of these other programs that Canada is creating during COVID-19 to assist people who lost work that are through the employment insurance program. So provincial student loans, that also doesn't count as social assistance. Neither do immigration loans if it is the person that is a sponsor that is, if the applicant is has one. Subsidized housing doesn't count either as social assistance. Tax credit, child care subsidies, public health care, services your province or territory gives to all people who live there, and basically any benefits you're getting through a workplace benefit program, like through your work or workplace injury claim as well. So you need as much evidence as possible to make your application successful. Uh, and if you're going through the common law route rather than the married route, you need even more evidence. So your relationship story is very important. You have to tell the story of your whole relationship right from the beginning. You have to have a very good knowledge of each other's personal histories. You may actually be interviewed as part of the processing of your application. The story of your relationship needs to convince the officer that you actually did meet, then develop a meaningful relationship that led to the decision to get married, or you want a married like common law relationship. So basically, a Las Vegas style wedding will be very unconvincing. Even if you have a marriage certificate, if the marriage seems to have come out of nowhere, then that application will almost for sure be rejected. So ideally, the combination of your relationship length, including marriage, is over 2 years. Ideally, your marriage is longer than 2 years, meaning you were married more than 2 years before you made your application. That puts you actually in a better position to have a more convincing application. So you need a lot of documents, and you need to start preparing all this like well in advance in order to have everything you need together. And anything not in English or French needs to be translated into English or French with proof of a certified translation. So there's a lot to it. So you'll have a much thicker application even if you have to translate a lot of documents. Overall, you could be looking at 200, 300 pages overall for what you're including in this entire application with the documents. So the sponsor needs proof of Canadian citizenship or permanent residence. So what's proof of Canadian citizenship? Well, birth certificate, passport, or PR card, etc. If you're married, you have to have your marriage certificate. If your marriage certificate isn't in English or French, you obviously have to have that translated, just like anything else. Police certificate. So that's criminal information from countries of residence of the applicant. That's not just the country of origin, but any country you've lived in for more than 6 months for the last number of years. This can take months to obtain these police certificates. So it's basically this whole sponsorship application process. It's something that takes many, many months to put together in order to get everything together on your target date when you want to actually submit it. You need the birth certificate of the applicant and any dependent children. That also has to be included. And if there's dependent children that the applicant has, but of course, there's a former spouse of the dependent children. What about that? Well, you actually have to have custody agreements that allow you to bring any dependent children to Canada if there's another parent. Or if the other parent has died, then you need a death certificate. So again, more and more evidence. When there's children involved, there's definitely a lot more evidence and a lot more documentation that's needed. So for genuine relationship evidence, and this is the really, really big part, is what you need to show that this is a genuine relationship and not the so-called marriage of convenience that the immigration officer, the doubtful immigration officer, thinks is just an attempt to try and get into Canada through a fake marriage or a fake relationship. So they will put everything under a microscope. So the kind of information you need, and again, this is an overview, this isn't really covering everything. The evidence, you need evidence that your families know about the relationship. So your mother, your father, both sides, both the sponsor side and the applicant side, really need to know about the relationship. And if they don't, you need to have evidence of why they don't, such as they are deceased or that you have had friction with them and therefore they weren't involved in any way. But you have to demonstrate all that. They have a pretty little picture basically of what everything is supposed to look like. All these families getting together, big marriage ceremony with lots of pictures, et cetera, et cetera. No problems at all. Everything is just this perfect picture, but almost nothing looks like that. So you have to explain everything. So you need photos of you together, including of the marriage ceremony. Lots of photos. Take as many photos as possible. Photos showing you together with family and close friends. The way it's explained in the application forms is that significant photos. So if just a picture of you, the sponsor, or the applicant alone, That's not really a very significant picture. Picture with significant people in the background, that's what's significant. Evidence that your close friends know about the relationships, and not just photos, but letters, email correspondences, invitations, et cetera, et cetera. Now, beyond actual ceremonial details, family memberships in gyms, clubs, et cetera. Joint ownership of a house if you have a house, or you're both on the lease of an apartment. Insurance policies, including your spouse, giving each other assets in your wills, powers of attorney, any other legal documents that where you're able to name a spouse as being a beneficiary. You've done that, things like that. Statements of support from families, employers, doctors, pastors, anyone of importance. Text messages, emails, and other communication with each other. Yes, I'm not kidding. They want to know what you're saying to each other. And you're showing that you're communicating in a way that people in a romantic relationship communicate with each other, like affectionate communication. So basically, they're looking for indications that it's actually this kind of an intimate relationship. Proof of taking care of kids together. This could be photos or that you're both covering kids' expenses, that you are involved in, for example, in school activities with the children or programs, whatever, anything like that to show that you're both involved in parenting. So what makes an officer suspicious? Well, are you just barely qualifying, such as you just got married, or were living together in a common law relationship for just a year, so just barely making the regulation cutoff? If the applicant had tried before and failed in an attempt to get PR, let's say failed 2 or 3 times, and it could seem doubtful to this doubtful officer that this is legitimate, and could see that, oh, this person is shopping around for a way to stay in Canada. Again, I'm not agreeing with this portrayal, but this is the way this doubtful officer will likely look at your application. If your age, culture, education, and social background seem to be very different, so do you actually seem like a match? This might seem really weird, but like I said, this is a microscope, and they're looking at age, culture, education. And this sounds very discriminatory, and it is. It is discriminatory to basically exclude someone from anything important based on age, or culture, or country background, et cetera. But a lot of leeway is allowed when it comes to immigration and refugee law, unfortunately. So it doesn't mean if you have age differences and cultural differences that you can't succeed. You just have to explain that despite these differences, we still formed a relationship. You're basically, you're showing as much evidence as possible of your true relationship, and going against the current of this doubtful immigration officer's suspicions based on these discriminatory factors. Is there a history of many short relationships on either side that seem to indicate a lack of interest and commitment? That's also a factor that indicates doubt for the doubtful immigration officer. Has the applicant failed to follow immigration rules in Canada before the application, like overstaying, unauthorized work, etc.? All these things are factors that would lead to more suspicion by an immigration officer. So in order to go to deal with any of these suspicions or anything that doesn't fit into the pretty little perfect picture that the officer has in mind, legal arguments can really help. So if you have a lawyer involved, a lawyer's letter to explain that the evidence doesn't fit, then and there's anything to make the officer suspicious, that there are reasons that the application should still be accepted, using previous cases where such differences didn't matter and the application was still accepted. So basically looking at legal history in Canada and showing that such differences actually are fine, and that relationships still are successful in sponsorships, by still having the genuineness of the relationship despite those differences. So the application process. So the process, as I mentioned before, it could take a long time to put it all together. But if you're in a position which puts you in a good position for sponsoring your spouse, you can start preparing the application and documents anytime. Like you get married, you have your marriage certificate. If you have any like other required documents, birth certificate, of course, you have a valid passport, you expect to still be valid by the time you make your sponsorship application. You just get everything together, put everything together, start making the copies that you need, and you can just methodically put it together. Now, getting a lawyer involved early makes sense if you decide to get one. And basically, we're talking about to really get together all the details that you need and to review it all to make sure you check it off. Everything's here. And you really look at it with your own microscope to say, is this convincing? Does this look like a genuine relationship to someone who's really suspicious? You need to really go through it methodically in order to make sure that it's something that is likely to take care of possible suspicions. And there's so much to it that it's often that the first time around that there's mistakes made and you have to correct them. So it's good to be really patient with it all. So part of the process also, it does include getting a lot of financial records, notice of assessment for the sponsor, and bank statements. You can include as much as you really want to. There's a certain point where it's too much, but really it's better to put more than less. More financial information to validate the sponsor has enough finances. You do need a letter from your employer, for example, that demonstrates you have income and that you're capable of supporting the person sponsoring, that you're sponsoring, the applicant. So that's crucial. Um, and you can apply for an open work permit while your application is being processed. But again, you can only work once you get it approved. And you have to maintain your status in Canada while you're waiting for your open work permit. It can take many months to get confirmation from the immigration office that your application is complete, and then more time for them to make a decision. It's over a year now, really, especially with COVID-19. It's really unclear what the exact timelines are, but it's quite a while, at least a year, likely much longer before you actually get a decision on your application. You have to stay together the entire time you're both in Canada, otherwise your application will be rejected. The whole cost of it, it's $1,050 for the application plus $150 for each dependent child. And it's important not to forget the kids. Even if the applicant has children, even if they're not included in the spousal sponsorship application, like they're not included as those who are intended to join the applicant in Canada at that time, the child still needs to be named and given an immigration medical exam in order to be included in a possible future application to bring in dependent children, which would be a separate application. So if you refuse, there's a couple of things to mention here very quickly. I'm just nearing the end right now. I went a little longer than I thought. Inside Canada versus outside Canada does matter. So if your spouse is outside Canada when you make the application, this is considered an outside Canada sponsorship. If you're rejected while outside of Canada, then you can challenge it to an immigration appeal court, and you have 30 days to do that. If it's an inland sponsorship, that's a spouse is inside Canada when you make the application. You can only challenge a refusal to the federal court, which really requires a lawyer, as is very formal. In the other process, it's better to have a lawyer as well. And you only have 15 days to file for permission to have a hearing. So there's a docket, there's a process called leave to for judicial review. You only have a little over 2 weeks to do that. So you have to move quickly on that. If you miss deadlines, I mean, it's possible to ask for an extension, but it's very hard. And often this means you have to do a whole new sponsorship, and they can use your old evidence against you, such as if your old evidence had a lot of problems with it. You have to explain yourself around that. So it's really important to try to succeed the first time around. So plan as best you can. So I'm done my part, and I guess we can move to questions now. I see a question. It's how long does it take to get a work permit? Um, all the processing times right now are really unclear due to COVID-19. So normally, a work permit may have been a very quick process. I can't even say exactly what the timeline is now due to COVID-19, but I can quickly check that in just a second here. There's a particular place you can go to check what the processing times are for different immigration applications. So I can just find that for you right now. Um, or sorry, this is a work permit, open work permit. Uh, so about 73 days is what they're saying right now. But honestly, it's uh, it's really very unclear if any of these timelines are actually accurate right now. So that would be, but at the time you actually make the application, so if it's made alongside of the sponsorship, then that's what they say the time is. But it's really doubtful right now that any of that's true. So another question. I see another question here that if a relationship started with a sponsor while a sponsor was in another common law relationship, will that affect the validity of the length of the relationship with the applicant? Um, yeah, I see someone is saying I don't think 73 days is accurate. Unfortunately, we've been waiting for 9 months for the open work permit. Exactly, it's everything is just way longer than what they're saying on the site. Um, So, moving on to the that question I was just reading, yeah, if you're in another relation, if the sponsor's in another relationship, then your relationship didn't truly like you could say that that's when the relationship began. That happens all the time. One relationship is starting as the other one is ending. But if you're trying to establish a common law relationship, your common law relationship, if you're the sponsor, your common law relationship with your spouse does not start until the other one actually ended, legally speaking, because your common law relationship is the only relationship you're in. So you could have started your relationship in like not speaking about the law, but just in terms of the actual truth of the matter, your relationship started before, but legally speaking, your common law relationship doesn't start until the other one really ended. Uh, what is considered a dependent child? A dependent child is um, somebody who is the applicant's child who is under 22 years old on the date that the application is accepted. Or it could be a child that's over 22, but due to a mental disability, unable to take care of themselves, and the parents still need to take care of the older child, then that could still be included as a dependent child, but you'd have to have evidence of that. So the key is 22. Is 22 on the date that the application is received? So the acknowledgement of receipt of the application, that's the key date. Okay, maybe I'll just go to yeah, question. So I have another question here. If you get a new job while your spouse's application is in, do you need to update that? If so, how? Well, if you have an open work permit, then you're not tied to a specific employer. But as far as updating information, if you do get if you do get a new job, any of your circumstances change, then that would come up in your interview if you get interviewed. But if you're on an open work permit, you're not tied to a single employer. You can change jobs. If the applicant has a DUI from the states, what happens? Okay, in that situation, the applicant has a conviction, then that applicant could be considered inadmissible to Canada, which could mean that even if you have a genuine relationship, uh, that the sponsorship would be rejected due to this inadmissibility, saying this person has a conviction for a DUI would be considered a serious offense. Uh, Therefore, uh, the application is rejected. However, in the case of spousal sponsorship, especially if there's children involved, if you have children together, the children will be affected by this. Uh, these could all be factors that you could include in your application. Uh, you would have to have uh, another application that you would put in uh, if you're like if the spouse was actually removed from Canada, then there'd have to be another application, which is called an authorization to return to Canada. If we're talking about someone who had a previous conviction and wasn't actually ordered out of Canada, then my guess is this person probably wouldn't be in Canada because they would have been rejected on any previous attempt to get into Canada. If they somehow are in Canada, then that would all have to be dealt with humanitarian arguments for saying why the application should be accepted due to the impact on the children, possibly due to the hardship. Well, the hardship it would cause the sponsor, the spouse, the hardship it would cause to the applicant returning to the home country if there's other great difficulties that would be faced. So it's possible to overcome. It's very difficult, though. If any information changes, I see if you're sponsoring, you get a new job while your application is processed. Do you need to update them? Yeah, yeah. If you're whatever the condition of your work permit is, you have to follow it. If you're required to update them according to your work permit, then you have to update them. Uh, Basically, you just have to follow whatever is in your work permit. Does an allegation of misrepresentation on an application to any facts, even small, irrelevant facts, or usually major facts that have been found to be false or misleading? It's everything. It's anything. It's a name, a date, an address that you got wrong. It's literally anything. I wish there was such thing as small mistakes when it comes to immigration applications, but they're all considered just mistakes. And uh, a lot of scrutiny is put on a, on both the sponsor and the applicant to not make mistakes. So it's really like uh, it's a fine line, uh, and there are such things as bigger mistakes. Like if someone failed to include a um, past uh, attempt um, to get into Canada that failed, or past record of overstaying or something like that, that would be considered more significant than misspelling of a name or getting an address wrong. But these are all things that would be dealt with. Like if an officer found something that was in the officer's view wrong, then that would be part of an interview. They'd ask about that, and it could all be included as misrepresentation. But the bigger mistakes would be harder to get past, but they could all lead to the same result, basically. Yeah, I'm just trying to follow this question here. Uh, okay, so the way I understand this question is someone is awaiting a work permit, an open work permit. Um, or hypothetically speaking, there's an open work permit application made. Uh, a person is already married, and what's the impact uh, of leaving the current job? Well, uh, if you're on, if anyone is on a work permit, that is the basis of their status in Canada is that work permit. Same thing if it's a visitor's visa or a study permit. That's the basis of the legal basis for staying in Canada, and that needs to be maintained unless you get a new one. So unless there's a new permit, unless you changed your conditions of your work permit from a closed to an open work permit, right? Like, for example, if a worker is in a situation where there was an abusive situation while in a closed work permit, that worker can apply for an open work permit uh, to get any other job um, and leave the job where there was abuse. But the work can only commence once you actually have the work permit, a new work permit. So, question about bringing family members. The laws of the country matter, like the whatever country the children are in. So basically, you actually need the legal authority to be able to bring your children. If if you're in a situation where there is a custody battle going on, and legally the other parent says, "I don't want the children to leave," and the courts in that country agree that the children need to stay, then those children uh, won't leave. Those children won't be able to be part of the application. They can't be. They can't be because they're legally bound to stay in the country. So the laws of the country do matter, and this gets all into family law, and I can't really get into any details, only hypotheticals on that. But the laws of the country do matter. There's international law. It's called the Hague Convention Against Child Abduction, which actually includes family uh, members without custody taking dependent children away from those with custody. So Canada is party to that, is part of that agreement, the national agreement. So um, that also has to be followed. So if the applicant has applied, if an applicant has applied from within Canada, right, and you're in a married relationship, then it like you already got married and uh, put in the sponsorship application. At that point, it's it's important to try and stay together. It basically um, what the expectation is that the the married couple remains living together if it's an inside Canada sponsorship. But if someone has to leave for an emergency, etc., then that just has to be dealt with. But let's just say the expectation is that that you remain together and only leave if you absolutely have to. What's a PSW? Oh, right, right. Um, okay. Just trying to figure out what this question is. Sorry, folks. So it's possible to do a sponsorship where the spouse is outside Canada. It happens all the time. Um, it's an outside Canada sponsorship. You can get married, and um, you begin the sponsorship application. You can get married in Canada outside, but the sponsorship application begins with the spouse outside Canada and is processed outside of Canada. That means it's an outside Canada sponsorship, and that can still work. But it's just all about proving that the relationship is a genuine relationship and there's basically as much contact as possible. And it's basically showing that the communication is steady, that there's as many efforts made to visit each other as possible, and so on. That's basically what is needed for sponsorship where the spouse is outside Canada. Of course, with COVID-19 now, everything is a little complicated for that, isn't it? So that needs to be factored in, and we don't really know how that's being dealt with now because, I mean, those applications, as many of them as they're actually happening right now, are still being dealt with. So as far as um, if I get the question, I'm not sure I understand this question. I'm sorry. It seems to be in a couple of parts. I have a question just about someone's a PSW. Will they be allowed to continue their career? And I thought it was referring to will they have to leave their country or the country of origin, I should say. Okay. All right. A situation where someone's dating two people at the same time, and which should be which one? Which one should which one should be the one that is the one you go through the sponsorship with? Well, I mean that's not a legal question. That's just I mean, if anybody is going to uh, go through this process of a sponsorship, it gets right back to what I said through the presentation. It's all about having evidence of a genuine relationship. That's what's needed. And if someone is intending to sponsor like someone else, spouse uh, wants to sponsor their partner, but they're both involved in multiple relationships, well, it's not really going to meet the test. It has to be at the time that the sponsorship is made. Not only do you have to have only one existing relationship, but you really need to show that that one relationship has has a history to it and has a future to it. So if there are multiple relationships going on, it just uh, it might not even meet the minimum legal test, but it also might just be very unconvincing, even if you're going back and forth between relationships, that that would likely be a legal barrier, and it would just fail. A question about having a family member come to support as a caregiver. Well, anybody who wants to come into Canada for work would need a work permit. So it wouldn't be as much as an invitation, as much as it would be uh, providing work. So it would be through a work permit. Or it could be as a visitor if it's not a formal job. Here's an interesting one. If if married recently and a relationship is ongoing for 2 years, see now, if married recently and a relationship is ongoing for 2 years, but the previous relationship separation was within the last year, is it better to wait to start the application 2 years from the previous relationship separation? So if what's being talked about here is a legal separation, like a legal separation agreement, then that is something that's actually quite important to have to really show the end of the previous relationship. Like if so, you can be married still and not having actually gotten a divorce and began a common law relationship. Some people remain married, but they're separated for years and they have new relationships, sometimes very long ones. Theoretically, that can actually work for a common law sponsorship, but um, it's definitely not as strong as actually having gotten a divorce from the previous relationship, unless there's some particular barrier to getting the divorce. Like maybe in your country of origin, it's very hard for you. Let's say you're a woman, and it's very hard for women to actually get a divorce, and your husband doesn't want to do that. In Canada, it's very different, where it doesn't matter what someone wants. If one of the two wants a divorce, then it's pretty straightforward. But in some other countries, it isn't. So you can get a situation where it's largely women that this happens to is unable to actually get a divorce, but then could possibly uh, just enter into a common law relationship or get an order in Canada for a divorce certificate. It's a little complicated, but there are ways to do that. I've seen it happen. Uh, yeah. So as far as how to make sure you meet the minimum threshold, I got to stop using these legal terms. Uh, the minimum amount of time. It's important, like for the relationship. It's it's important to make sure that you have one relationship and only one relationship for if you want to have the strongest application for 2 years. And if you're in a common law relationship, you have to at minimum be living with only one person, be in only that one relationship for that 1 year. But that's a weak application. Ideally, it's much longer than that to be convincing. How much does the process usually cost? How much do lawyers charge? How much do paralegals charge? How do you identify a scam? Those are all really good questions. So the basic cost of the application is 1,050 plus the cost for 150 for each dependent child. And if you have to translate any documents, then there are those costs, and that it depends on the size of the document, but it could be like several hundred more for that. And that's not really for lawyer charges. That's just for the costs of putting the application together. Um, Generally, what you'll see for a lot of lawyers charging for sponsorships will be in the range of 2,500 to 5,000, in that ballpark. Sometimes a little bit higher, but it'd be hard to find anything much lower than about 2,500. I see a clarification here. Um, Clarification on question 8. Yeah, I don't know the answer to that. Sorry, yeah, I'm just not able to come up with an answer for that one. Okay, question here. I'm working in Canada for more than 11 years now. What can I do to stay in Canada? I go back and forth every time. I stay for 9 months each year. Well, uh, coming to Canada as a migrant farm worker, if that's the situation, uh, could happen for 25, 30 years, and it doesn't actually improve at any point in time the chance of getting permanent residence. It's just staying in the same place, and that's the fault of Canada for not doing anything about that. That should have changed a long time ago. It should change right now. There should be PR on arrival, um, but there isn't. So as far as someone who keeps coming to Canada through a temporary program like the seasonal agricultural worker program, I mean, the thing is that program is by design uh, designed to be permanently temporary. So that's the problem with it. So the only way around that is to change the program that you're in. So if you are sponsored, for example, through a spousal sponsorship, that changes your course. If you came to Canada on a study permit instead and kept going through school and then got some experience in your field, then you could apply through a different program uh, called the Canadian Experience Class if you become a skilled worker that can qualify for PR through that other stream. Now, that's possible. So there's other possibilities, but it would be changing the program basically. But coming in year after year through the seasonal agricultural worker program, unfortunately, and again due to the fault of Canada, does nothing to give someone an improved chance of getting PR. Can an employer be a sponsor? Well, employers can be involved through nomination programs. An employer can be, well, is the one who is crucial for any um, like skilled worker PR program as being the one who provides that permanent job. But if the question is, can an employer be the one that is actually uh, the spousal sponsor, there's no actual legal barrier to that. Whether or not anything looks suspicious is a question. So a question about a family member sister coming in as a caregiver. So this isn't specifically about sponsorship. Um, so there are people who can come to Canada as essential workers. You have to specifically qualify it as an essential worker. If you're a particular kind of a healthcare worker, you can be qualified as an essential worker. Those are specific rules. I'm honestly not quite prepared to talk about that this evening, um, but there are specific categories to which someone can come as an essential worker. They have to qualify. They have to go through all the required COVID testing, etc. But that's just something that this is a subject for another day, basically. I think we're getting ready to wrap it up now. I've had a lot of questions, so I've tried to answer the questions to the best of my ability. Um, but let's just say, in the best of situations, there's an opportunity to do some more thorough uh, legal research to get into anything really specific. That's why I mentioned at the outset, it's very difficult to get into really specific answers to very specific questions, because that's exactly why someone needs legal advice, because every unique situation requires a unique approach in many cases in order for that situation to be properly dealt with. Someone who read about points needed for express entry being lowered from 400 to 75. Is there any way for SOP workers to benefit from this? I haven't seen that. Um, the thing about the point system is you you need to fit into a specific category of worker that's called a skilled worker. And the sad reality is, as skilled as farm work is, um, it's not, Canada is not actually calling it skilled work. And that is a real barrier to even being eligible for the express entry program. Unless someone saw something very new, but I haven't seen anything like that. The express entry program, you have to fit into this box of what Canada calls skilled workers, and there's certain job descriptions, and seasonal agricultural workers just aren't there right now. And again, I think that's terrible, but it's just the way it is right now. Thank you, everyone, for coming out tonight. I hope this was helpful to lots of folks, and encourage you all to keep doing your own research and get legal advice if you need it for anything specific.